Good evening, one and all. To have a speaker, good evening, one and all. To have a speaker again on a different topic, it only shares two aspects. Number one, speaker has immense knowledge that he can share his knowledge on different aspects of law. And secondly, he is very popular amongst the participants when participants are willing to hear his knowledge. And the Electricity Act 2003, though has traveled the journey of around 17 years, but there are still certain areas for which any common man, because as they say, Bijli Sadak and Pani, that is the electricity also plays a constituent role in one's life. And to understand as to how the Electricity Act 2013 has developed from the Electricity Act of 1910 and Electricity Act of 1948, because it allowed certain privatization and some companies, and as to whether how the Telegraph Act would apply when the laying down of the lines is there, and what is the subtle difference between the word unauthorized connection and a theft, because these as a lawyer or a common man we see largely there is litigation in this regard as to whether the connection, if there was some kundi connection as we say in Punjab, or unauthorized connection, or once there is extra load, whether it will fall within the review and parameters of an unauthorized connection, or if we are laying out an extra line and it's not connected to the meter, whether it would be theft. These are the certain journeys, aspects which will be discussed and shared by Mr. N.L. Raja, a senior advocate of Madras High Court, who is not only known in the commercial aspect field specialization, the Arbitration Act, but Electricity Act is also one of his main forte. Consequently, taken to all these aspects, we requested Mr. Raja to share his knowledge. And as usual, he was kind enough to accept to the same and share the knowledge. And we will also be sharing the PPTs which Mr. Raja has prepared for this webinar amongst the group of Beyond Law CLC. So those who are connected in the group or the WhatsApp, they will be able to have the bird eye view subsequently, even though this video would also be uploaded on the our Beyond Law CLC channel of YouTube. Thank you, sir. And on a Friday evening, it's always a pleasure to hear you.
Good evening all. I'm so glad that on a Friday evening, there are so many of you gathered to talk about a topic which is really not a very exciting one, but still that shows the level of interest that you have to learn law. When the use of electricity, it is said, was demonstrated to the President of US, then President of United States, he is believed to have remarked, this is all very interesting, but would it have any practical use? From that time, in about 140 to 150 years, electricity has traveled so much that it's become an integral part of our lives. We can't today imagine a life without electricity. And next to air and water, I think today it is the most important element in our lives. Whatever we do, even the Zoom call, everything is possible only if we have electricity, and it has become so integral to our lives. There is a very interesting book by a writer called Alvin Toffler called Future Shock. And he says, if you are to condense the entire life of humanity on Earth into 24 hours, then electricity was actually discovered in 23 hours and 58 minutes, right? So if you take the entire life of humanity on Earth and condense it to 24 hours, electricity was discovered in the 23 hours, 58th minute. So just 2 minutes of that has made such a remarkable change in our lives. And this is just the beginning. The type of changes electricity is going to bring into our lives is truly going to be stupendous. And there is also this observation that in the last 150 years, the battle for supremacy between nations was between labor and capital. Entire political systems were created around capitalism and communism, which are basically economic principles. And we created entire political systems out of it. But in the last about 10 to 15 years, this has become irrelevant. Now, if you have capital in China, you can probably engage labor in Africa. And if you have capital in the US, you can engage people down south in where I live and close to where I live, Karur, Erode. So it really, and there is a person who will be sitting in Manhattan telling you the difference between the count of fabric from a factory made in Tirupur and possibly a factory made in Karur or Erode. So that is the extent to which the village has become global. So in this century, what does a nation need to attain supremacy? And two aspects are very important for, among other things, two aspects are important for a nation to attain supremacy in this century. And those two things are energy, energy as in power, as in the various types of energies we have today, like the solar energy, the wind energy, fossil fuels, biomass, all these come within the nuclear, all these come within the classification of energy. And second is ideas, right? It is these two which are going to power a nation. So it is electricity is really the backbone of all the progress that a nation can plan. Please bear this in mind, and this is why it is today essential to have a sensible law relating to electricity, a user-friendly law relating to electricity, and a law that will be effective and produce results. Right? So without that, the nation cannot hope to progress at all. So that is how integral electricity is to the progress of a nation, and that's why we need to understand the nuances relating to the Electricity Act, which is an important component in ensuring stable and better electricity. Now, I would request the organizers to start my PowerPoint presentation. I'll take you through it. As I was telling Mr. Vikas, this is a huge ocean. So, in a period of about an hour and 15 minutes, it's going to be very difficult for me to go into various nuances. Especially, you will understand that this is a law in which is the concurrent list. So, both the state government and the central government have jurisdiction to deal with it. And therefore, there is a whole lot of regulations that have been passed by state electricity regulatory commissions and the governments. And therefore, this is going to make the task of my presentation even more difficult because, for example, if I tell you this is the position in Tamil Nadu, it may not be the position in Punjab. It may not be the position in West Bengal. Those regulatory commissions may have completely different laws that apply to them. Right? Please bear this in mind. This is why I am trying to only concentrate on the general aspects of the Electricity Act 2003, the nuance and what has been dealt with by the Supreme Court of India. Can I have the PowerPoint presentation? The Electricity Act. The next. In India, generation and distribution of electricity commenced with the demonstration of electric light in Calcutta, which was conducted on 24th July 1874 by a company called Curie and Company. Then on 7th January 1897, Kilburn and Company secured the Calcutta Electric Lighting License as agents of the Indian Electric Company, which is registered in London on 15th January 1897. Before independence, electricity generation and supply were concentrated in the hands of private electricity suppliers. These suppliers were largely in urban areas. With the object of regulating the generation, supply, and use of electricity, the first legislation relating to electricity was enacted as the Electricity Act of 1897. This legislation was subsequently replaced by the Indian Electricity Act 1903. The Indian Electricity Act was only a stopgap arrangement till a more comprehensive legislation came into effect. And therefore, the Electricity Act of 1910 came into effect. Next, please. The Indian Electricity Act 1903 was repealed and it was enacted as the Indian Electricity Act 1910. And the Indian Electricity Act provided the basic framework for supply of electrical energy. The sector being at a nascent stage required huge investments, which we envisage to be fulfilled by private license. So, what is very significant about this phase of electricity generation in our country is that much of it was in the hands of private entrepreneurs. Yes. And I should say we have come a full circle after trying. Then we went into completely state-owned SEBs, as we call them, the State Electricity Board, and then that experiment having not worked very well, in 2003 we went back to privatizing most aspects of electricity sector. Next, please. Have the next slide. So under the provisions of the 1910, generation plants were established. The first one was set up at Calcutta, and then Bombay. Then with the independence, priorities changed, and electrification was planned to be extended across the length and breadth of the country. And therefore, we needed a law to address this. Then, therefore, came the Electricity Supply Act 1948, and this act was based largely on the provisions of the UK Electricity Supply Act 1926. Next. There was substantial growth in the power sector in terms of installed capacity, transmission network, and distribution to various areas across the length and breadth of the country. However, over a period of time, a number of problems surfaced. Right? The SEBs, as they are called, the state electricity boards, became financially sick and ridden with huge debts. And just before the Electricity Act came to be passed, the cumulative amount due to various agencies from SEBs exceeded 41,000 crores. The demand supply gap was huge. There was so much of demand for electricity, but then the state electricity boards were unable to supply this huge demand. The quality as well as quantity of power was poor. The vote bank politics compelled the tariff to be kept artificially low for the agricultural sector, which prevented the rationalization of tariff. While it is understandable that we must have low power tariff for agricultural sector, there's absolutely no logic to completely making it free for the farmers, or putting in place a system which did not permit the government to subsidize the losses which power sector generators were incurring on account of free supply to the farmers. Next. The foundation of reforms was laid in the 1990s, with the private sector participation being encouraged in generation. That is only in generation, mind you. PTC Power Trading Corporation was created for power trading and various other initiatives. Then the first attempt at reform came through the provisions of the Electricity Regulatory Commissions Act, and the purpose of which was to distance the government from tariff determination. Therefore, what was envisaged under the provisions of the Electricity Regulation Act was that the government will not have a significant say in the manner in which the tariff was to be determined. It was supposed to be determined according to the rules and regulations which were to be put in place by the Electricity Regulatory Commissions. Next, please. Can I have the next slide? So the objectives of the Electricity Act 2003 can be stated to be as follows. To consolidate the laws relating to generation, transmission, distribution, trading, and use of electricity, for taking measures conducive to development of electricity industry, for promoting competition, for protecting the interest of consumers, to ensure supply of electricity to all areas, rationalization of electricity tariff, ensuring transparent policies regarding subsidies, promotion of efficient and environmentally benign policies, constitution of authorities like the Central Electricity Authority, regulatory commissions, and establishments of appellate tribunal, distancing tariff determination process from the government. So this broadly captures the various objectives of the Electricity Act 2003. Next. Electricity being a concurrent subject, as I told you earlier, a well-coordinated approach would be necessary for the development of the power sector. This is essential for the attainment of the objective of providing electricity access to all households and providing reliable, uninterrupted quality power supply to all consumers. The state governments have a major role, particularly in the creation of generation capacity, state level transmission and distribution. The central government must assist the states in attainment of this objective, and it would be playing a supportive role in fresh capacity addition and a major role in the development of the national grid. So to say, the Electricity Act empowers the central government to lay down a broad framework within which this reform will happen. And it is also duty bound to guide the development of this of the progress in electricity. You will frequently read in papers that the central government has put in place, long kilometers of transmission facilities, that it is trying to pull certain SCVs out of the red by giving them grants. Then there is this Uday scheme under which state SCVs are encouraged to subscribe and to get relief on the basis of certain conditions which are important for generating competition. So this is the coordination between the central government and the state government, which is very, very important for the development of the electricity sector. Next. I should tell you at this point that if you are going to specialize in the electricity laws, it is essential for you to know certain technical terms, because electricity is a technical subject. If you don't know the technical terms, you will find that you are often getting tripped in before the commissions or the courts, who will start throwing technical terms at you. So basically, you must understand certain terms under the electricity. Once again, the terms and the which are in use in the electricity sector are very many technical terms, and I have just put in here a few important terms which you need to bear in mind. And once again, all this is with the purpose of kindling your curiosity, right? I may not be exhaustive in the manner of information that I'm giving you, but these are all pointers. These are things that you must look up and learn and try to understand these concepts before you get into the electricity sector as an actively participating participant in the electricity sector. That becomes very important, and therefore I would request you all to look up these terms and learn more about them. I am just giving you a bare framework of what these actually mean. An electric current reverses its direction. A current that flows only in one direction always is a direct current. A current that reverses its direction many times a second at regular intervals is an alternating current. Ampere is a unit of measure of intensity of an electric current. So you have an electric current flowing, you must also measure its intensity. It is measured in terms of amperes. Circuit is a closed path in which electrons from a voltage current source flows. Circuits can be in series, parallel, or in any combination of two. A circuit breaker is an automatic device for stopping the flow of current in an electric circuit. To restore service, the circuit breaker must be restored after correcting the cause of the overload or failure. That's a circuit breaker. Next, please. Next. A conductor, any material where electric current flows, you've all heard of good conductors and bad conductors. Any materials where electric current can flow freely, conductive materials such as metals have a relatively low resistance. Copper, aluminum wire are the most common forms of conductors. The flow of an electric charge through a conductor is what is called a current. An electric current can be is like a flow of water in a pipe, and it is measured in amperes. Like how flow of water in pipes is possibly measured in liters, this is measured in amperes. Demand, the average value of power or related quantity over a specified period of time. You will hear terms like maximum demand, minimum demand. This is basically indicates the average value of power or related quantity over a specified period of time. Then I told you the direct current is a current that flows only in one direction. An electron is a tiny particle which rotates around the nucleus of an atom, and it has a negative charge of electricity. Next, please. A fuse. This is very common. All of you would know about it. It is that thin metal rod which ensures that if there is going to be excess electricity flowing through the circuit, then the fuse burns off to prevent further damage to the equipments and to the system. And then you need to restore the fuse for that to function effectively again. A generator is a device which converts mechanical energy into electrical energy. And ground is, you also have heard that you need to properly ground the electricity connections. That is the reference point in an electrical circuit from which voltages are measured, a common return path for electric current, or a direct physical connection to the earth, which is the most common form in which it is understood by all of us. And an insulator and a conductor are actually the opposite. An insulator is any material where electric current does not flow freely. Insulative materials such as glass, rubber, air, and many plastics have a relatively high resistance. Insulators protect equipment and life from electric shock. That is the purpose of an insulator. Next. An inverter is an apparatus that converts direct current into alternating current. And a kilowatt hour is a product of power in kilowatt and time hours equal to 1000 kilowatt hours. For example, if I am saying if a 100-watt bulb is used for 4 hours, at 0.4 watt hours of energy will be used. And this gives the conversion with regard to which helps you to measure the product of power and time. A kilowatt hour meter is a device that is used to measure electrical energy use, and a load is anything which consumes electrical energy, such as lights, transformers, heaters, etc. Next. Power is the rate at which electrical energy is transferred by an electrical circuit, and it is measured in watts. Power factor is very important, and you will hear about this quite frequently in the electricity laws. It is a ratio of actual electrical power dissipated by an AC circuit to the product of the RMS value, current and voltage. The difference between two is caused. Primarily, a power factor is an indicator of how efficient an electrical system is in an establishment. If you have a good power factor, which means that your electricity systems are running efficiently, the connections have all been given properly, and the maintenance of the equipment has been done well, all this is an indication of a good power factor. And the opposite is when you do not take care of your equipment, it is all not structured properly, there is a lot of wastage of power, your power factor may be low. A rectifier is an electrical device that converts an alternating current into a direct one by allowing a current to flow through what? The resistance, the opposition to the passing of an electricity current. So anything that has high electrical resistance, you would possibly refer to it as an insulator. Anything that has low electrical resistance, you will refer to it as a conductor. Next. Come to the next. So semiconductor is a solid substance that has a conductivity between that of an insulator and that of most metals, either due to addition of an impurity or because of temperature effect. Devices made of semiconductors, notably silicon, are essential components of most electronic circuits. That again is a huge industry, making semiconductors and electronic circuits. This is why we have that Silicon Valley, which all of us have heard about. It is a huge industry and is also into making chips. That is a completely different area relating to computers. But primarily, semiconductors are something which between that of an insulator and that of most metals, either due to addition of an impurity or because of temperature effects. And short circuit is one part. This is again, we have heard this quite often. When one part of an electric circuit comes in contact with another part of the same circuit, diverting the flow of current from its desired path, you say that there has been a short circuit. A transistor semiconductor or device with three connection. Transistor in application to electricity loss and the electricity area is a semiconductor device with three connection capable of amplification in addition to rectification. Volt ampere is a unit of measure of apparent power. It is the product of RMS voltage and the RMS current. Volt is a unit of measure of voltage. When you have, when you want to transmit power through long distances, you use high voltage power. So when you use high voltage power, then there is lesser wastage of electricity, and that is why you have this concept of step-up transformer and step-down transformer. Anything that is generated is then converted into high voltage. It is then transmitted over long distances, but then you have to receive it in your house at probably between 100 to 220 volts, and therefore it is all stepped down, and then it is in a position where you can use it on your household articles. So this is how it is measured, a unit of measure of voltage. Next. Voltage is an electromotive force or pressure that causes electrons to flow, and can be compared to pressure which causes water to flow in a pipe. The pressure that makes water flow in a pipe, you can compare it to the electromotive force that causes electrons to flow through a conductor of electricity. Voltmeter is an instrument for measuring the force volts of an electrical current. This is the difference potential voltage between the different points in the electrical circuits. Voltmeters have a high internal resistance and are connected across parallel to the points where voltage is to be measured. Watt hour is a unit of electrical energy equivalent to a power consumption of 1 watt for 1 hour. You say that I'm using a 100-watt bulb, then it means that it is using 100 watts per hour, right? So this is what it is supposed to indicate. The next please. Watt, that again is something which we have heard of quite frequently. It is a unit of electrical power. 1 watt is equivalent to 1 joule per second, corresponding to the power in an electric circuit in which the potential difference is 1 volt and the current is 1 ampere. Watt meter. So you need to measure this. The equipment that you use to measure this is called a watt meter. Is an instrument for measuring the electrical power in watts of any given circuit. So as I said, these are fundamental terms in electricity that you need to learn. There are more complicated terms which you can leave safely to an electrical engineer. But if you are going into the practice of law, it is essential that you acclimatize yourself with the meaning of these terms and their application in electricity laws. Otherwise, understanding certain concept of electricity law may become difficult. This is a very, very good area for youngsters to step in. I have this one advice to all youngsters, that if you want to develop a good practice, always keep looking out for emerging practices of law, right? The existing practice of law will usually be very crowded. Civil codes, criminal codes, existing areas of practice may be very, very crowded. This is why you have to be constantly on the lookout for emerging areas of practice, because there the competition will not be as intensive as in the other areas. For example, GST today. GST is a huge area for practice amongst youngsters. So you must read GST law. You must attend webinars like this. You must write articles relating to that. You must attend conferences in which the nuances of GST law are going to be discussed. With all this, then you will pave the way for acquiring a practice in those laws, because people who are doing well in traditional areas of practice may not be inclined to step into these fields because they are new and they don't want to risk getting into this. That is a huge opportunity for youngsters to step into these areas, learn about them, and therefore profit from that. Can you go to the next slide? Policies are very important because they lay down the path which uh, a sector has to travel. So under the provisions of the Electricity Act, one of the unique features of the Act is that it contemplates framing of policies regarding various aspects dealt with under the Act. The framing of these policies must be the central government in consultation with the state government, electricity commissions, and wherever required stakeholders are also consulted. Framing of the national electricity policy, all of them have a statutory backing. The National Electricity is Section 3 of the Act. National tariff policy of a national electricity plan is Section 3.4. National policy permitting standalone system for rural areas and a national policy on rural electrification and local distribution in rural areas. In respect of all these policies have been set down by the central government. The policy gives the map, the direction in which the sector has to travel. That is the utility of a policy. And having defined it in those terms, it is essential that it is revisited frequently to look into what improvements must be made. Next. One of the most important features of the delicensing in generation of electricity, one of the most important features of the Act is that it provides delicensing in generation of electricity. There are just a few exceptions, primarily being hydroelectric generation and nuclear power generation. You can't now step into that without getting a license from the government. But all other types of generation have been delicensed. Section 7 of the Act specifically provides any generating company may establish and operate and maintain generating station without obtaining a license under this Act, which if it complies with the technical standards relating to connectivity with the grid referred to in Clause B of Section 73. Next. Next. Yeah, Section 4, and these are all the manner in which the generation of electricity has been delicensed. Hence, the following two conditions to be met to satisfy the requirements of this section is that the area should not be connected to the grid. That means the area should be an off-grid area. The area should be a rural area notified by the appropriate commission. If you satisfy that, you can set up a standalone system. Theoretically, it is today possible for a housing society. Let us assume that you are living in a colony which is about 2000 households. It is theoretically possible for you to set up a generating station and which will supply power only to that station. How it is done is the power generated is once again pumped into the grid, and from the grid the licensee, which is the state electricity board, is going to give you power in your household. But the point is that theoretically it can be done. Whether it is being done is a different issue. I have to tell you that no, from 2003 to 2020, we have not traveled the path where actually people start experimenting with use of setting up small power generation plants in their colonies to take care of their power needs. But theoretically, under the provisions of the Act, it is possible. Next. The second is open access. So once you generate electricity, you need to have a carrier through which the electricity is transferred, isn't it? That's why you have provisions for and under the provisions of the Electricity Act, access to open access is a right which is statutorily given to you under the provisions of the Act. The provisions of the open access users under the Act enable heavy users with more than 1 megawatt connected load to buy cheap power from the market. The concept is to allow customers to choose from a number of competitive power companies rather than being forced to buy power from the local utility monopoly. It not only helps industrial and commercial consumers by ensuring regular electricity supply at competitive rate, but also enhances the business power market. Open access helps consumers to meet the renewable purchase obligations. As the name suggests, RPO is an obligation on state power distribution companies. Now, what has happened? Not only has it become necessary for the state to encourage power through other renewable power options like wind and solar, but it is also necessary for the various state electricity boards to buy, and also for private users to buy a particular percentage of their consumption which are manufactured through this RPO methods. So there is an obligation which is imposed, which is called the RPO. There are once again nuances relating to that, which you can understand if you go a little in depth into the subject. Next. The Act also encourages competition at the micro level as the distribution is liberalized and the distribution networks are allowed along with the introduction of open access, and the consumers will have the choice of electricity supplier. As there will be competition at micro level, the consumers will have better service for reasonable price. This is the basis for encouraging this. As they say, the role of the regulatory commission is to ensure that there is more competition in the field, because as they say, the power and the duties of any regulator in an area relating to competition is to see that competition is preserved, protected, and propagated, and it is no business of the regulator to protect the competitors. The competitors are not the subject matter of protection, both under the Competition Act and in many of these regulatory acts. The purpose is to ensure that competition is protected. Therefore, starting from the micro level to the highest level, the provisions of the Electricity Act mandate that competition must be encouraged and protected. Next. Trading in electricity is also now permitted. You have this IES exchanges, and like the stock market on a day-to-day basis, the power charges vary. All the purpose of all this is to ensure that the consumer has a choice. One of the most important thing with regard to a consumer's right is a right of choice to the consumer, and this ensures that if I can go in for my own captive generation plant. If my captive generation plant on a particular day is costlier than my purchase through the exchange, I then buy through the exchange. If my exchange price and the captive generation plant are going to be more expensive than the state electricity board power, on that day I take the state electricity board power. So these are various choices that are now available to a consumer simultaneously. Just because you have a captive generation plant, it does not mean that you cannot go for IEX exchange. All this is in general, and as I said, it is all subject to the regulations which have been brought out by the Regulatory Commission. But in general, these are the principles that are supposed to apply. Next. Authorities to resolve conflict. The other important provision is the Electricity Act provides for a hierarchy of authorities. Now, this is very, very important for a lawyer to know which complaint should I take before which authority. Many times complaints get thrown out because wrong authorities are approached with regard to adjudication of issues which are not within their purview. So it is essential for a lawyer to understand the hierarchy of authorities created under the provisions of the Electricity Act. It provides for there are two different compartmentalized columns as far as dispute resolution is concerned. One is between the consumer and the licensee, the state electricity board in most cases, but if it is privatized, any licensee. So that hierarchy is different from the hierarchy between the generator and the licensee. That again is a different column, right? So the hierarchy as far as the consumer and the licensee is concerned, the lowest level is the CGRF, as we call it here in Tamil Nadu. I don't know what they are called there. It's a Consumer Grievance Redressal Forum. Each superintending engineer has a Consumer Grievance Redressal Forum, and from his order, you can file an appeal to the Ombudsman. From the Ombudsman order, if you do not find the order of the Ombudsman satisfactory, you have to go to the High Court by way of a writ petition. Now, as far as the disputes between the generator and the licensee are concerned, generator licensee disputes can only be taken before the Electricity Regulatory Commission. From the orders of the Electricity Regulatory Commission, you have to go on appeal to APTEL, which is the authority at Delhi and is the apex authority as far as this hierarchy is concerned. That is the hierarchy relating to the generator and the licensee. And from any order of APTEL, you can go to the Supreme Court. There is a third hierarchy, which is the Supreme Court has clarified in the PTC case, that in respect of regulations brought out by the electricity authorities, neither the Ombudsman nor the CGRF nor the electricity regulatory commissions have jurisdiction over them, and it is only the high courts which can be approached with regard to a challenge relating to any regulations brought out by the electricity regulatory commissions. And from the order of the High Court, obviously an appeal will go to the Supreme Court. So there are three compartments really, which determine on the basis of the nature of the complaints which you take before these authorities, which authority is empowered to determine which issue. I go to the next. The transparent regulator, the Act enables not only operation of trading regime in electricity, but also provides for a regulator. Hence, the Electricity Act has provisions for IRC at the central level as at also at the state level. Next. Can go to the next. Reorganization of state electricity boards is again a very important aspect. The Electricity Act encourages the appropriate governments to recognize the state electricity board. There is punishment of theft of electricity. I will deal with it a little more towards the end of my presentation. It also provides for punishment of electricity. It creates separate codes. I would say, instead, probably the word that I should be using is, it empowers the notification of separate codes to deal with complaints relating to theft of electricity. We go to the next. Understanding the key concepts under the Act, you need to understand the concept of national electricity policy, which I talked to you about some time back. It is basically to deal with laying guidelines, accelerated development of power sector, providing support electricity to all areas, and protecting interest of consumers and other stakeholders, keeping in view available of energy resources, technology available to exploit these resources. All this is dealt with. As I told you, it is a map. The government is laying down a map for traveling down that path. Next. Then there is a national electricity plan that assesses in the country in this year how much demand will there be and how are we going to provide for it. The assessment of demand is an important prerequisite of planning capacity addition. Section 3(4) of the Act requires the Central Electricity Authority to frame national electricity plan once in 5 years and revise the same from time to time in accordance with the national electricity policy. So these two have to act in tandem. They need to be coordinated, the national electricity policy and the national electricity plan. The combined objective of these two is to lay down the policy after assessing the requirements of a nation for the next 5 years. It's like the 5-year plan that we used to have in economics earlier. An equivalent of that is the national electricity plan. Next. So generation, as I told you, has been completely delicensed, has been put in a highly liberalized framework for generation. There is no requirement for licensing of generation. The requirement of techno-economic clearance of CEA for thermal generation is no longer there. For hydroelectric generation also, the limit of capital expenditure above which the concurrence of CEA is required would be raised suitably from the present level. Captive generation has been freed from all controls. Next. Transmission, central government would facilitate the continued development of the national grid. The national grid is like the NHAI. It is National Highways Authority of India. Like that, in the electrical sector, you have a national grid which takes power. So today, the power generation in, say, some part of Rajasthan is very good. It is possible to transmit the power from Rajasthan here to Tamil Nadu, and the basic infrastructure by which that is done is through these large transmission lines. The central transmission utility and the state transmission utility are authorities which have been created to constantly keep upgrading the facilities for transmission in a state. Next. The distribution. Now, after you get the power, let's assume you get the power from Rajasthan, it comes all the way from Rajasthan through these transmission lines and then it reaches Tamil Nadu. You need to have an agency which will collect that power and to distribute it. It is like a farmer producing something in the agricultural field. He grows the crops, it is transported, it comes to a mandi here. After it comes to a mandi, for it to reach you, it has to come to the local provision store. The person who is in charge of taking it from the mandi and bringing it to your local provision store is the distributor. The person who operates a lorry and brings it from where the farmer produces the produce and brings it to the mandi is a person who is in charge of the transmission. This is the basic analogy. Distribution is the most critical segment of the electricity business chain. The real challenge of reforms in the power sector lies in efficient management of the distribution sector. The Act provides for a robust regulatory framework for distribution licensees to safeguard consumer interests. It also creates competitive framework for distribution business, offering options to consumers through the concept of open access and licenses in the same areas of supply. Now, what is important about distribution is, even though theoretically distribution has also been delicensed, distribution requires huge investments, right? And most people are very, very reluctant to put in that amount of investment and come into that area because they don't think that they can depend upon governments to give them stable policies. So this is another great threat to development of the electricity sector in India. Someone was asking me about the reform bill. Some part of the reform bill, I'm not going to go into that in detail, but some part of the reform bill also seeks to address these issues with regard to how do we, boost the market for distribution in this country. How do we get private sector investment into distribution? Today, private sector doesn't want to touch distribution with the barge pole. They are afraid, because if you put in money and create a 1 megawatt generator, you're not putting in a whole lot of money. And if something goes wrong, you can always take this whole investment, write it off as a loss. But that can't happen with regard to distribution or transmission, in which crores and crores will have to be invested. So there is no confidence to put the money in that sector as of now. And this is what the government is constantly working on. It is hoping to improve the climate for investment in distribution lines. And some of the reforms that we are talking through, the bill will also address this. Next. Then let us come to the basic element of the electricity. Why does all this exist? All this exists to give the consumer a better deal. And a consumer means any person who is supplied with electricity for his own use by a licensee or the government or by other person engaged in the business of supplying electricity to the public under this act, or any other law for the time being in force, and includes any person whose premises are being connected for the purpose of receiving electricity, works of a licensee, the government, or other person, as the case may be. So this is a very simple definition of the consumer. I must also tell you that the provisions of the Electricity Act do not bar you from going to the Consumer Protection Court, the consumer courts for relief, because as the Consumer Act in Section 3 says, that act is not to be read in derogation of other laws. And this act also does not prevent a consumer from going to a consumer court. Therefore, his choice is, if he has a problem, he can go either to the consumer court or he can file an application before the CGRF. In my practical application, in my working, as far as Tamil Nadu is concerned, CGRF delivers a judgment much faster than the consumer courts today here in Tamil Nadu. I don't know the experience in other parts of the country, but if you have a problem with the electricity sector and you have a consumer, and if you think that you should take it to an authority, it is better for you to go before the CGRF. The CGRF is also, you have a representation of a consumer organization in CGRFs in Tamil Nadu. I don't know how it is in other parts of the country, which makes those authorities very, very effective and efficient. Next. Can I go to the next? And a distribution licensee likewise means a licensee authorized to operate and maintain a distribution system for supply of electricity to the consumers in this area of supply. The Electricity Act 2003, the licensing is still necessary for a distribution licensee. As I told you, for generation, it is not necessary, but it will still be subjected to rules and regulations. But as far as the distribution licensee is concerned, it is essential to have a license, and you can't do that work without a license. Next. State electricity regulatory commissions are actually the spine and backbone of this entire system, and every state government is required to constitute, for the purpose of the Electricity Act, a commission to be known as the National State Electricity Regulatory Commission. The purpose, powers and duties of the Electricity Commission are set out in the Electricity Act. Primarily, there are three types of functions which a state electricity commission does. It sets down the laws, rules, and regulations which it is empowered to pass under the provisions of the Electricity Act. Secondly, it adjudicates disputes between the licensee and the generator. Thirdly, it also has a consultative role to play. So when the state governments want to consult the state commission, they are free to do that under the provisions of the Act. Therefore, there is a threefold duty cast on the state electricity regulatory commissions to perform. And if they perform what has been assigned to them, then the electricity sector can really undergo a transformation, which is the purpose of the Act itself. Next. The dispute redressal, I've already told you about it. I don't want to dwell more on it. It is the CGRF, Ombudsman, and from there to the High Court. In respect of the consumer generator licensee disputes, it is at the first level to the State Commission, and from there on to APTEL, and from APTEL to the Supreme Court. And if you're going to challenge regulations, it is going to go to primarily the High Court, and from there it goes to the Supreme Court. So this is these are the three main compartments. There is, of course, the fourth compartment with regard to electricity and unauthorized use of power, which also I will come to. Next, standards of performance. Once again, under Section 57 of the Electricity Act, the State Electricity Regulation may, after consultation with the legislature, every state electricity commission is supposed to lay down the standards of performance. For example, if I apply for an electricity connection, how long should my application, within what time should my application be disposed of, is a subject matter of standards of performance. It also says that if I apply for an electricity connection and connection is not given within 30 days, then I am entitled to compensation. These are standards of performance which the state commission has a duty to set down. All states, they have set down these standards of performance. If I have to buy a meter, what must be the nature of the meter that a consumer must buy, how quickly must it be installed. All this is supposed to be regulated under the standards of performance. And even if I have an unscheduled power cut, let us assume I have an unscheduled power cut for an entire day, the standards of performance authorize me to move the consumer grievance redressal forum for compensation if I have suffered unscheduled power cut. Still, in the country, there are large areas which undergo unscheduled power cut, but unfortunately, the awareness that you can go before a CGRF and claim compensation is not very well known, and therefore we do not keep tab of all the unscheduled power cuts that we have, nor do we approach the CGRF for this compensation. But under the provisions of the Act, you can approach those authorities. Next. Open access is what I have told you. It is just an access to a carrier which will take your electricity as soon as it is generated, as soon as it is manufactured. You need a carrier who will bring it to you, and that is the open access provisions, and these are dealt with in Section 42 of the Act. Next. Plant load factor, as I told you earlier, this is a very important component and is a measure of how effectively and efficiently your machinery and your establishment is functioning. One of the major achievements of the power sector has been a significant increase from 2003 to 2020. One of the things that we have actually achieved is the plant load factor of many of the establishments are doing pretty well, which is an indication that our entire system is becoming better and better. Next. Metering. The Act mandates supply of electricity through a correct meter within a stipulated period. The authority should develop regulations as required under Section 55 of the Act within 3 months. The Act requires all consumers to be metered within 2 years. The SERCs may obtain from the distribution licensees the metering plans, approve these and monitor the same. These again become the responsibility of the state electricity regulatory commissions. Today, in respect of most of the industrial unit, it is possible for the electricity board. Previously, they used to come for inspection, checks, etc., etc. Now, the metering is so effective that they don't have to leave their office at all. They just need to sit there and monitor when there is a hike in the consumption, when there is a dip in the consumption, detect abnormalities in the consumption pattern. All this they can do sitting in their own offices. That is the advantage with bringing in a better metering system. Next. So cross-subsidy surcharge is very important. What is this cross-subsidy surcharge? Primarily, the argument with regard to cross-subsidy surcharge is this, that if the generator spends, let's say, 100 rupees to generate 1 unit of electricity, then from that, some part of it is spent towards supplying electricity to the less privileged sections of society, like agriculturists, like hut dwellers. All these people are supplied electricity either at nil price, which is not a very good thing to do, or at highly subsidized rates. So therefore, the price which an electricity generator charges you includes that subsidy component. Now, if you're going to move away from that, and if you're going to go to a private producer and buy his power, then the state electricity board or the licensee loses that money. Therefore, to compensate the state electricity board for that subsidy component it loses, when the consumer goes away from the state electricity board and goes to a private producer, this concept of cross subsidy surcharge is introduced. and that is determined by the State Electricity Regulatory Commission. It says you are free to go to a power producer, and you are free to take power from him. But if you do, in addition to what you will pay him, you will also pay a cross subsidy surcharge to the State Electricity Board to compensate the State Electricity Board, which is then providing subsidized power to poor people. Now, that is the concept of a cross subsidy surcharge, and there are plenty of litigation with regard to this. And once again, many matters turn up before the Electricity Regulatory Commission and before the APTEL on how exactly it is to be levied and what are the contour, what can it not exceed, what are the limits within which it should be collected. All this have become subject matter of a lot of litigation. Next. You go to the next. So, what are basically the nature of complaints that land up before the consumer court? A delay in sanctioning new connection, electricity meter running fast, unscheduled load shedding, erratic power supply, low excess voltage supply, voltage fluctuation, not replacing burnt meter, delay in restoration of supplies due to distribution failure, delay in transfer of ownership category, delay in reconnection subsequent to disconnection due to non-payment, delay in refund of advance consumption deposit, consumption security, meter security, delay in shifting of meter connection lines, non-issue of due certificate, delay in redressal of complaint. These are largely consumer related complaints. This is not between the generator and the licensee. This is all in the nature of the type of complaints that go before the CGRF and before the ombudsman. Next. Consumer Grievance Redressal Forum therefore have the powers to deal with these types of complaints. Next, please. The powers of the CGRF have jurisdiction to entertain the complaint filed by complainants with respect to electricity service provided by the distribution licensee and to take up suo motu if the same fulfills the requirement specified. The forum shall entertain only those complaints where the complainant has approached some appropriate authority of licensee as prescribed in the complaint handling procedure. Therefore, there are procedures laid down. You can go into the website of the Electricity Regulatory Commission of the state. It gives you all the particulars with regard to this. Next. Next, this is all a continuation of that. So this again is powers of the, then the higher authority is electricity ombudsman. If a consumer is still not satisfied by the order of the consumer, he can file, make a representation before the ombudsman. Matters, there are certain areas which are excluded. Section 126, 127, 135 139 and 167 of the Electricity Act are areas which are reserved for other authorities, and you can't go before the CGRF or the electricity ombudsman with regard to complaints relating to the same. Next. Next. The most important aspect of the electricity law is the determination of tariff. Unlike in the past, electricity tariff is not determined either by the. Now it has become it has become an economic process. How do you determine a tariff? Previously, it used to be determined by the state government, and you have any number of Supreme Court judgments which say that this is a legislative function, and therefore the power of the court to interfere with the setting of tariff was extremely limited. But now it has become a statutory function. This is why against that function an appeal lies. What primarily does an electricity regulatory commission do when it sets tariff? There is something called the ARR. ARR is the annual revenue requirement. I manufacture electricity, I sell electricity. I spend 100 rupees in manufacturing electricity. Under the provisions of the Electricity Act and the rules and regulations framed thereon, annual revenue requirement is a cost of all that, what material I need, what wages I pay to my employees, what money I spend in maintaining the equipments, what do I do by way of upgrading my equipments. All this is part of the ARR. So first thing that the State Electricity Regulatory Board has to do is it has to submit all the bills for that and say that, listen, this is how much I have to spend the next year with regard to maintaining infrastructure. Now the commission takes note of that, and then it sees how many units uh, are manufactured, how many units are generated by the state electricity board, and then it comes to a mathematical exercise for this amount of electrical energy for you to generate, and if this is your spending, how much must you charge per unit? Then it arrives at as an average figure. From that average figure, there are two classes of consumers: subsidized classes of consumers and subsidizing classes of consumers. A subsidized class of consumer is a consumer who is paying less than this cost of manufacturing 1 unit of electricity, right? And a subsidizing consumer is somebody who is manufacturing, who is paying more than this cost of manufacture of power, and a subsidized consumer is somebody who is paying less than this cost of manufacturing 1 unit of power. The act now requires, why did the state electricity boards land up with huge problems? They landed up with huge problems because there was a mismatch between what they generated, what they spent, and what they could recover from the government. So all of them went into losses. Now the Electricity Act says that you can't do that. Now what the government has to do is, if it says these classes of consumers are I'm going to subsidize, the State Electricity Commission is supposed to fix the cost of that subsidy, and the government will have to pay that in advance. So the scheme is such that in tariff setting, the electricity boards will never suffer a loss. This is the purpose this is the primary objective of tariff setting, to see that state electricity boards do not suffer a loss. If you ask me, in spite of it, why do they suffer a loss? It's a long story. I don't have time to deal with it here now. But in spite of it, because the tariff setting process is in the first place not very accurate, there is delay in recovering the money from the government, and the tariff is not set every year as it should be. These are various multiple complications which lead to still there being a shortfall between the generation of electricity and what the state electricity board is able to recover from its customers. Next. Go to the next. Yeah. So all this is the tariff determination process. I put it all here for you to read at leisure. As I said, within the time frame available, it's not going to be possible for me to go into all this. But I've made these notes for your use and utility, because you can go through this in greater detail. Will you come to the last part where we have this set of case laws? Because I think the last slide has the list of case laws. Just go beyond this. The last slide has this case. This I have sort of set out the scheme of the act. This again is for your instruction and for your information. You can go through this at leisure. I will come to the last part with regard to the major cases that have been decided under the Electricity Act. And then these are the important judgments. Please go to that before that. West Bengal Electricity Regulatory Commission. If you want to understand the electricity regime, please read these acts in detail, these case laws in detail. These are very, very important. I'm not saying that these are exhaustive, but these are very important for you to understand. Please go to. I have also given a brief note. Primarily, West Bengal ERC versus CERC. The question before the Supreme Court was whether the consumers have a legal right or not to be heard in the proceedings. This was under the 1998 Electricity the Regulatory Commissions Act, because for the first time, previously the consumers would not be heard when a tariff was fixed, but for the first time under the Electricity Regulatory Commissions Act, a right was given for the consumers to be heard, and this right was upheld by the Supreme Court in this judgment. Go to the next one. So this case is also important as to whether the High Court sitting as an appellate court. Previously, when this judgment was passed, APTEL was not in existence. So the appeals would go to the High Court, but the question there was, when I go to the High Court as an appellate authority, this question arises frequently. When a High Court is functioning as a statutory authority, its powers are circumscribed by the provisions of the statute. It cannot borrow from its Article 226 powers because it is only functioning as a statutory authority. This principle was also laid down in this case. Next. The next question is, who determines the tariff? all that was decided in that case. PTC India Limited versus CERC is very important for creating the third compartment that I was talking about. It said that neither the State Commission nor APTEL can go into validity of regulations brought out by the state government or the commission itself. For example, the State Electricity Commission brings out a regulation which is not in line with the law. You can't go before the State Electricity Regulatory Commission itself and to file a complaint there. So this compartment, the third compartment that I was talking about, was created through this judgment, and they said that this can only be challenged before the High Court and the Supreme Court. Next, this case is also important for a whole lot of other issues which I have set out here. Please read this judgment extensively. It will give you a very good, bird's eye view of the Electricity Act and what the authorities under the Act are supposed to do. Next, all these are the questions that have been decided in this case. And CESA Sterlite is on the issue of cross subsidy surcharge, how it must operate, how it applies, etc., etc. And this again is very instructive on the issue of cross subsidy surcharge. Next, Gujarat Urja Vikas Nigam Limited is an interesting case which went into whether the provisions of the Arbitration Conciliation Act will apply or the provisions of the Electricity Act will apply in respect of appointment of an arbitrator. It invoked that principle of interpretation of statutes which said that the specific will always override the general. Arbitration Act 1996 is a general provision, but when under the provisions of the Electricity Act, you have powers for the commission to appoint arbitrators, only that can be invoked. Next. The Tamil Nadu Distribution Limited versus PPN is again an important judgment which held that the first appeals under the Electricity Act can re-examine the regulator's discretion with regard to if the regulator had, the State Electricity Regulatory Commission has appointed an arbitrator. The question was whether APTEL could go into the question and determine whether the appointment of the arbitrator was correct by the State Commission. And the court also held that it could be done, and the APTEL was empowered to do that. This also laid down a very important principle, which I then took to the High Court, and it said that the Electricity Regulatory Commission must be headed by a person who has basic judicial training. And it said that it should be headed by a High Court judge. Therefore, I filed a petition before the High Court to say that our State Electricity Regulatory Commission must be headed by a High Court judge. Gujarat also a similar judgment was given, which said that it should be headed by a High Court judge. The matter ultimately went to the Supreme Court. Supreme Court went into the provisions of the Act and said it partly allowed our arguments and said that yes, what you're saying is right. The commissions must have a legally trained mind, but it is not necessary that that legally trained mind must be the chairman of the commission. But one of the members must have a legal training, on account of which, under the before the Tamil Nadu Electricity Regulatory Commission, we now have a judicially an extra district judge to be one of the members of the Electricity Regulatory Commission, and the regulatory commissions all over India now have at least one judicial mind among the three members. Next. Reliance Infrastructure versus State of Maharashtra is all about the power of the commission to set tariffs. And how tariff policy is important. For example, if a tariff policy delineates and specifies a particular thing which must be done by the State Commission cannot ignore that and set the tariff. And therefore, the implication of the national tariff policy in tariff setting was examined by the Supreme Court in this case. Next. Best versus BRC, the Regulatory Commission, this is an important issue with regard to the first compartment that I talked about in respect of disputes, that in respect of a dispute between a consumer and a distribution licensee, the proper authority to examine that would only be the Consumer Grievance Redressal Forum. And in this case, the appropriation of that jurisdiction by the State Electricity Regulatory Commission was held to be improper by the Supreme Court. So this is very useful for that first compartment of disputes that I talked to you about. Next. Once again, this also goes into the issue of consumer filing a petition before the commission. and it was pointed out that such petitions will not like. There is one area in which a consumer can actually approach the commission straight away, and that is where the regulations are not being implemented properly. Where the regulations that are being framed by the commission are not being implemented by the authorities properly, my argument would be that the powers under the Electricity Act empower the commission even on a complaint by the consumer to deal with it and to punish the licensee or any authority who is acting in derogation. This is a position that I have also argued before APTEL, that the power is available, and some of these matters are still pending before the before APTEL for APTEL to take a decision on that. But that alone, I would say that there is power for a complaint to be filed by a consumer if any of the regulations are being consistently being floated by the licensee. Next, please. This again is an elaboration of that judgment. Tata Power and Reliance Energy Limited is a very important judgment on competition and how competition between, for example, in this case, Tata Power and Reliance Energy is important and is in the interest of the consumers. So the court gave due recognition to the objective behind the Electricity Act to promote competition and give the consumer an option to choose. So anything that is in derogation of this right of choice of the consumer, the court frowned on, as it did in this case. Next. So this generally is the conspectus. I will quickly deal with one important issue which Mr. Vikas wanted me to deal with, and which is with regard to the difference between section 126 and 135. Very simply, there are two important judgments that is not part of my compilation, so please note it. Executive Engineer versus Sitaram Rice Mills, 2012, 2 SEC, page 108. That considers extensively the difference between section 126 and 135. And now there is a recent judgment, which is the West Bengal Electricity Distribution Company Corporation versus Orion Metal Private Limited, which is 2019 SEC Online 1077. I don't think this has been reported in the SEC, but it is the SEC Online, West Bengal State Electricity Distribution Company versus Orion Metal, ORION Metal Private Limited. It is 2019 SEC Online 1077. So these two cases, if you read, primarily the difference is this. Section 2026 is with regard to unauthorized use of electricity. In an unauthorized use of electricity, the electricity department need not prove any dishonest intention. Right? There is no necessity for the department to prove any dishonest intention. Section 135 is a criminal offense. And as you all know, that a criminal offense, for it to be established, you have to prove dishonest intention. And a complaint will have to be filed before the police, and the police will have to file further proceedings before the court that has been designated under the provisions of the section 135. Many times the question arises, can a person be sued simultaneously for section 126 and 135? This is one question that frequently arises. Section 126, let us assume there is a case where I am a tenant of the property. There is somebody who has used the premises earlier. My earlier tenant has tampered with the meter, and he has caused some loss to the electricity department. The electricity department did not detect this at the time when it was used by the previous tenant. But when I came into possession of the tenancy, they conducted an inspection and they found that electricity, there is unauthorized use of electricity. Now the question is, can they proceed against me for theft of electricity? No, they can't proceed against me for theft of electricity. But can they proceed against me for unauthorized use of electricity? Yes, because whether I have an intention or not, I am still using electricity, which is not the manner in which it should be used according to the terms and conditions. Right? That is one example. The second example is, suppose my sanctioned load is a particular kVA and I use more than that. Right? Now, am I using unauthorized use of electricity? Yes, because I am authorized to use only a sanctioned demand, and I exceed that sanctioned demand, and on an inspection done by the authorities, it is shown that I have exceeded the sanctioned demand. Therefore, I am liable for unauthorized use of electricity. Therefore, if you read these two judgments, it will be clear that under section 126, what needs to be assessed by the electricity department is only the loss that is caused to them on account of unauthorized use of electricity. The establishment of an intention is not necessary at all. Whereas for the department to succeed in a case of section 135, they must show that there has been dishonest intent. For example, in a dishonest intention, I go and break a meter. I go and break an equipment. On account of that, I try to take an advantage, but no advantage actually ensues. Right? In that case, I am guilty of theft of electricity. It cannot be said that there is no case because I don't have a case under 126 because I have not actually benefited from this entire process. You can't file a case against me under section 135. There would be cases where complaints can be maintained purely under 135. There would be cases where complaints can be filed purely under 126. There would be cases where complaints can be filed simultaneously both under 126 and 135. All this depends upon the nature of the offense that is alleged and the circumstances surrounding the charge and complaint against me. That is the most important determinant, and it has to proceed only on the basis of that. So this, I think, answers issues with regard to section 126 and 135. I am thankful to you for giving me this opportunity. I've gone on for 1.5 hours, but as I said, this is a vast ocean, and there is much to learn, and it is a great area for lawyers to actually start specializing in. Thank you once again for giving me this.
Yes, sir. As rightly said, that the act is very vast, and as we were discussing earlier also, then one aspect which we would like that we can specifically have one webinar on this 126 and 135, because primarily young lawyers invariably get the litigation qua, whether it is an unauthorized connection or whether it's a theft, and whether the jurisdiction would lie under section 153 or not against that, as to what are the remedies for that. And then next question arises is, normally one feels that once the laying down of the lines is there, as to whether the Land Acquisition Act will prevail or the provisions of section 10 to 16 of the Telegraph Act would prevail. So we'll bother you once again and ask you to give insights on these aspects also. Because at least I have seen in Punjab Haryana High Court, these two type of litigations are primarily there, as to whether that electricity theft, if you have done, it is compoundable or not, whether the FIR could be quashed, whether if we see that unauthorized connection, they always say that unauthorized connection would be like you have taken a connection of 5 kilowatts. Instead of 3 ACs, you are installed the 4th AC. So it becomes an unauthorized overhead. And the theft would be what we say a kundi connection, that you take an electricity from a source which is not actually being detected to a meter. So these subtle differences, we would like that you should share your knowledge on 126, 135, and section 67 of the Telegraph Act as to whether it will be notified or not.
We will have a separate.
Yeah, that's what I'm saying. I know that. In fact, because I do not know about Madras, but in our side, we have primarily this type of litigation, especially of the laying down of the lines. They say that it's my farmer's land. My land has been totally spoiled. They say that I should be compensated. Then that Kerala state transplantation case, a plantation case comes, wherein they said how you have to assess and give this thing, because right of compensation is only qua the damage done, not because the land is not acquired. You continue to retain and become you are always the landowner itself. 2-3 questions have come in.
We will deal with it in a separate session. There is also the works of licensee rules and regulations. There are a lot of rules and regulations, because in a matter, one of the High Court judges wanted clarification of this. They gave him the works of licensee regulations. So many of the lawyers don't know that these regulations exist and actually regulate the manner in which transmission lines should be laid, and the authority to whom we can file a complaint for compensation, and what are the powers of that authority. All these are set out in various rules and regulations, and we only see the act. So those are important topics, but I said this is very vast. What possibly we can take is 4 or 5 important questions. You can probably call it 5 important questions in electricity laws, and we can discuss it.
So that's what I'm saying: 126, 135, 153, then Section 67 of the Electricity Act. According to me, these 4 sections are, and fifth one would be as to those who are practicing on the PSR EC, we say Punjab State Electricity Regulatory Commission, or HERC, what you said, the Regulatory Commission. But that is a very niche area where that requires a super specialization of the regulatory commissions. Because how the transmission layer, how the tariff rates would be calculated, how the annual assessment would be there.
Yes.
This is Dr. Shrikant. With the emergence of the EVs, do you see a shortage of production? And if yes, how can the law bring in the regulatory of tariff with the privatization of the charging points, if any?
With the generation of?
With the emergence of the EVs, do you see a shortage of production? And if yes, how can the law bring in regulatory of tariff with the privatization of the charging points, if any?
No, tariff fixation, there is no problem at all. And as far as primarily, we need to have more privatization in the sector as things stand today. And only if the sector is privatized more and more, and we are able to, the Electricity Regulatory Commission comes up with some sensible standard for setting tariff. Would there be, and now with the IEX power, where I'm able to buy power from any part of the country and at very, very affordable and economical rates, I would say that it is only going to improve. Notwithstanding the fact there are a lot of roadblocks to the SEBs becoming extremely effective and efficient, but what the saving grace is privatization is helping in a large way.
This is again by Dr. Shrikant. With regard to cross subsidy, would you have an opinion as to whether the agreement between the distributor and the producer can be arbitral?
Distributor and the generator can definitely be arbitrated. It can only be arbitrated, and or it can be decided by the commission. If the commission feels that there are too many intricate aspects to be gone into, the commission has the power to refer the matter to arbitration. But I don't think any consumer can force the commission to refer the matter to arbitration when it says I am in a position to determine the matter myself.
Stanley is a plaintiff staying in this family property for a long time under his possession. The defendant fraudulently got a will and changed the government documents, including EB connection in his wife's names. The dispute is going on since 2009 in a sub-court as a partition suit. Can the defendant give a letter to the EB to close for permanent closure? Since EB connection has been changed from plaintiff's mother's name, in case the EB disconnection the line, what is the remedy for that?
See, EB is not, I don't know about the position in other parts of the country, but as far as Tamil Nadu is concerned, the EB is not concerned about family disputes at all. EB is only interested in supplying electricity to you and you paying for it. So the system that we have in Tamil Nadu is, whenever something like this crops up, the EB gets an indemnity bond from you, saying that whatever be the ultimate outcome of these litigations, I will be the person who will be responsible for making the payments. In fact, the law in Tamil Nadu is to that extent where it says, even if you put up a construction in, let us assume, government Porambok land, as we call it here, still the electricity board has to give connection and it has to supply and it has to collect the charges for the supply that it makes. So leave alone a dispute between the landowner and somebody else who's claiming rights with regard to the property. Even if the dispute is between the government and the person who is illegally occupying government land, still the electricity board cannot refuse to grant connection. And all that the electricity board must be interested is in correcting tariff for the power that it supplies. And it gets an indemnity bond from the person to say that if for any reason there is to be any issue with regard to this, still I continue to be responsible.
So one Armstrong has asked the question, but I think we will take it in another webinar. What are the procedures for EB to follow in the case of theft of wire and in case of theft of energy? That's what we are saying. Until unless we understand that concept, this question will be Johnny. What are
All these are
what are the procedures of EB to follow in the case of theft and in the case of theft of energy?
all this, as I said, are regulated by different rules and regulations which have been formulated by different commissions. So you will have to, there is no uniform rule that applies right across the country. Every electricity board has brought out its own regulations to regulate this. And therefore, I can't give a general answer with regard to this.
Yes. So we have no other questions. I'm just telling about the tomorrow's webinar. Before we part for the day, tomorrow the webinar would be on burden of proof vis-a-vis the owners of proof and standards of proof. This is by Justice Mandata Sitaraman Murthy, a former judge of Andhra Pradesh. Do log in at 5 p.m. for the insights on a quite an intriguing topic. And thank you to all the participants who have been watching us live on the Facebook and on this platform. And thank you to Mr. N. L. Raja, the senior advocate. A topic which is quite vast, but it was funneled in the right perspective, which every common man can understand. And we will be sharing these notes on the WhatsApp group. And thank you once again, sir. It was a pleasure hearing you. Namaskar, sir. Jai Hind to everyone.